Now we turn to a clash at home and a major development in these criminal January 6 probes. This is new DOJ evidence that really shows how much planning went into the crimes of the insurrection. There was a documentary film crew, we're learning, that actually went inside a meeting in a D.C. parking garage between the Proud Boys and the Oath Keepers, controversial right-wing militias, and it was on the eve of the insurrection. The crew at one point picked up audio of a person referencing the Capitol, according to the court filing, which suggests the groups may have been more closely coordinated, planning for what to do on January 6th than many publicly knew. A judge also is ordering the Proud Boys leader, Enrique Tarrio, to be held in custody in jail until his trial. Now, all that is on the criminal prosecution side. Then there's the other legal side of people who aren't accused of crimes but are accused of, well, a lot. Take Jeannie Thomas, the wife of Supreme Court Justice Clarence Thomas. Now, all this time later, suddenly admitting she did attend the Stop the Steal rally on January 6th, which is relevant to her husband's jurisprudence. It renews questions about how he, Clarence Thomas, has been using his power on the bench, because Justice Thomas did something that no other justice did, no other appointee from Trump or any Republican did. He was the sole dissenting vote in the decision that basically told Donald Trump he could not block records from being handed over to Congress in this important investigation. So, as mentioned, the other justices had said, yes, the legal question was clear. Those powers are held by Congress, and the evidence goes. But not Clarence Thomas. And then you add this context now that his wife was involved in the thing that he was trying to keep secret. Ginny Thomas not only attending the rally, but as previously reported in The New Yorker, she published multiple posts on January 6 on Facebook saying, "Watch this MAGA crowd," and then, in all caps, "God bless each of you standing up or praying." That was on January 6th itself. She later said she wrote those things before she knew about the level of the violence. I'm joined now by former federal prosecutor Joyce Vance. Welcome back.
Good to see you.
Good to see you, too. And obviously a lot going on, but this is important here in America. My first question is the shortest, then we'll build. Does this information add to the weight of legal evidence that Justice Thomas should recuse from these type of cases?
It really does, Ari, and I'll just use a personal analogy. My father-in-law was a federal court of appeals judge. He did not sit on cases that came from my law firm or my husband's law firm, because that would have been an obvious conflict of interest, and it would have caused people to question the integrity of his rulings in the judicial system. So Justice Thomas has the same situation. No one is saying that Ginny Thomas needs to limit her activities, but if she chooses to engage in this sort of political behavior, the full scope of it, then Justice Thomas needs to be very careful about recusing from cases where his involvement in a matter that she has an interest in could tarnish the court's reputation.
Right. As you say, legally, obviously, she can go speak and do legally protected activity. She can also start a bakery. But if that bakery has a case that reaches the Supreme Court, her legal right to bake doesn't mean that Justice Thomas should be ruling on whether she pays a penalty or anything else. I mean, it's all quite straightforward. His dissenting vote in that case was so noticeable. We reported at the time. What do you think, if anything, is gleaned here, that he has his own view of the separation of powers, or is it possible that this hits too close to home? Because, boy, Ms. Thomas, with all due respect, didn't disclose this information in January or February of that year. This has been kind of withheld, it would seem.
And this is exactly the problem. Because the Supreme Court, all of the justices are sort of free agents when it comes to ethics. They don't operate under the same rules and constraints that federal judges or federal prosecutors or just members of the bar do. So it's incumbent upon them to be very careful and to police their ethics on their own. And the problem here is exactly the one that you point out. Was Justice Thomas's lone ruling in the Trump turnover case, was that a part of his jurisprudence, or was it motivated by something else? We don't know. That tends to cast the court's integrity into doubt, and that's precisely the sort of situation justices and judges need to avoid by recusing from cases that could call the court's integrity into question.
Yeah, and as you say, we are not issuing a final report or confirmation of his motivation or what was in his mind. But we are reporting for people to understand they have great power, they have lifetime tenure. And it seems to me that if you went to January 6th, you went to that rally that turned into the insurrection, and you came home that night, it might come up at dinner or the next day. It doesn't seem like something that the justice logically would never have known about. So we're getting, this is what's interesting, I guess, to me as a journalist, we're now learning later what they likely knew and discussed then. Or to put it more carefully, Justice Thomas has not publicly denied that he knew about this earlier than the rest of us. I want to turn to the other story as well. You see evidence the DOJ had that's now coming out because of the process of these prosecutions, that they have more confirmation of these meetings before the 6th. How and why could that matter for them proving cases beyond the simple stuff, a trespass, disturbing government property, to the idea that there was something more organized among at least potentially some defendants?
We've got important lead charges in these newer cases. The Oath Keepers case, of course, is where DOJ for the first time has charged seditious conspiracy, and that charge is different because it requires proof of an intent to use violence or some sort of a violent component. But more frequently, DOJ is using a charge that involves obstruction of an official proceeding or conspiracy to obstruct an official proceeding. And we're starting to see the government's evidence, which frankly was already pretty good. This came up in the context of a detention hearing for Enrique Tarrio, the leader of the Proud Boys, and DOJ just sort of drops into its pleading a couple of important details. For one, that there was a meeting between the leader of the Proud Boys and the leader of the Oath Keepers before the leader of the Proud Boys was forced to leave the District of Columbia in advance of January 6th because he had gotten caught up in another criminal case where he was ordered to leave. And so this, maybe it's a changing of the guard meeting. We don't really know. We don't know a lot about the substance. But it's interesting that DOJ decided to use it in this detention hearing. They had a lot of evidence that they could have chosen to use. They're using both this and a memo that lays out sort of a scheme, a game plan for attacking buildings on the Capitol this early on during this detention hearing.
Yeah. Really important breakdown on more than one piece of it. So I'm interested to get that from you, Joyce. And all I can say with everything going on is nothing good to say about the world, nothing that good to say about this story here on the home front. But it is good to see you again, Joyce Vance. So thanks for coming back.